Good afternoon, everyone, and thank you so much for joining this program hosted by the Brennan Center for Justice at NYU Law School. My name is Wendy Weiser, and I'm the Vice President for Democracy at the Brennan Center. For those of you joining one of our events for the first time, the Brennan Center is a nonpartisan think tank and public interest law center that works to repair and strengthen our systems of democracy and justice so they live up to America's ideals. Before we get started, I have a few housekeeping points. First, we will leave time for questions at the end of the discussion. If you have a question you'd like to ask, please add it in the YouTube chat. Civility is important to us at the Brennan Center, and those who post rude or intemperate language in our message streams here will be removed from the conversation. Second, we provide live closed captioning, and the program will be available for screening on YouTube, so please do share it widely. Now, I am delighted to welcome you to our conversation today, the first in a series of convenings that will address the Independent State Legislature Theory, a radical and anti-democratic new interpretation of the U.S. Constitution being pushed by some conservative activists. Proponents of this theory argue that two clauses of the Constitution, the electors and the elections clauses, give state legislatures exclusive and virtually unchecked power to regulate federal elections without interpretation by election officials and without any checks from governors, state courts, or even state constitutions. If the Supreme Court adopts this theory, it could completely upend and undermine voting rights, redistricting reforms, and election administration. Hundreds of longstanding election rules could be immediately wiped out, including the secret ballot in Oregon or absentee balloting in 20 states. In its most extreme form, this theory could enable state legislatures to even overturn federal elections. Alarmingly, 4 justices have already embraced this theory in recent shadow docket opinions, and there's a real risk that the theory could gain a majority next time the issue reaches the court. That moment may be soon, because the court is now considering whether to grant cert in a North Carolina redistricting case in which the petitioners are asking the court to adopt the Independent State Legislature Theory. Fortunately, a wave of recent scholarship has debunked this theory from every conceivable angle. It is baseless as a matter of history, text, and practice, and makes no sense as a matter of policy. This scholarship will be vital in convincing the Supreme Court to step away from this dangerous theory. With us today are 4 of the preeminent scholars who have written these important works. Their accomplishments and contributions are too numerous to describe and outline in the few minutes we have, and so I'll only briefly introduce them and their affiliations, but I encourage you to take the time not only to read their CVs, but their scholarship. So first, I would like to welcome Dean Vikram Amar, the Iwan Foundation Professor of Law at Illinois College of Law. I also welcome Leah Littman, Professor of Law at the University of Michigan Law School, and Carolyn Shapiro, Professor of Law and Associate Dean for Academic Administration and Strategic Initiatives at Chicago-Kent College of Law. And finally, Kate Shaw, Professor of Law and the co-director of the Florsheimmer Center for Constitutional Democracy at Cardozo School of Law. I am also delighted to welcome our moderator for today's conversation, Wilfred Codrington, a Brennan Center Fellow and Assistant Professor of Law at Brooklyn Law School. Wilfred, take it away.
Thank you, Wendy, and thank you to all the participants in today's important discussion. So I think we should just start sort of broadly, and I'd love to ask a question generally for the entire panel. Elena Kagan, current Associate Justice on the Supreme Court, said that we are all originalists now. What does founding era history and practice reveal about the independent state legislative theory, and how faithful are the members of the court to this history? And I'll open that for anyone.
Well, Wilfred, I'll jump in since no one else did. I was going to wait for others, but I'll take a shot. First of all, on your second question of how consistent justices are in applying originalism, that's quite a complicated question. I think, Next year in the Harvard and University of North Carolina affirmative action cases, you're going to have some justices say things that are very inconsistent with the text and original understandings of the 14th Amendment. But as regards the so-called ISL, Independent State Legislature notion, I think originalism cuts entirely against it. And indeed, I haven't even seen anybody try to argue to the contrary. The Articles 1 and 2 both do use the word legislature of the states, but legislature of the states was understood at the time as an entity created and limited by the state constitutions and the state peoples. There's no way to think about a state legislature except in terms of what powers it has, but also what limitations it has coming from state constitutions. The Articles of Confederation and the practice under that confirm this. The Articles of Confederation used language very similar to Articles 1 and 2. And the early post-constitutional actions by states in adopting new state constitutions after 1787 confirm all of this. So the only thing that the conservative justices who've embraced ISL have is the bare use of the word legislature. But text without context is not originalism, and legislature has to be understood in terms of what people thought it meant at the time, as well as the actions that people took that reinforced that meaning. The only historical stuff that people adduce in support of ISL is 19th century stuff that has nothing to do with originalism. I don't care whether people got it wrong in the late 1890s, the same time they got it wrong in Plessy versus Ferguson. I care as an originalist what people were thinking and saying in 1787 and shortly before and shortly thereafter.
And can I add, there's practice from that time. We know that at least 5 states' original states' constitutions included provisions requiring, for example, that all elections, including federal elections, be conducted by ballot as opposed to voice vote. And that was a controversial question at the time. So we know that even at the founding, there were state constitutions limiting what state legislatures could do with respect to federal elections, and that was seen as completely normal.
Well, I'm going to fast forward us up a bit to 2000. All of your articles discuss the independent state legislative theory in the context of Bush v. Gore, the role that case played, or those cases, the Bush 1 case in the remand and Bush 2 in the recount, played for the development of this theory. Can you explain that, how it came up in the dispute? And while you're at it, really, whether that was the actual origins of this, or if this theory has other antecedents. And again, this is one of these questions where you all touch on Bush v. Gore, so I'm happy to hear this one from any of you.
Well, I'll just jump in and say a couple of things and let others pick up. It came up in Bush v. Gore in 2 ways. It actually originally came to the Supreme Court in the pre-existing case, Bush versus Palm Beach County Canvassing Board. And there, the Florida Supreme Court had interpreted aspects of Florida election law, at least arguably by reference to the Florida Constitution, sort of a constitutional avoidance technique. And the Supreme Court said, well, we can't really tell how much the Florida Supreme Court relied on this Florida Constitution, so we're just going to remand because it could be a problem if they relied on it too much. It's not a holding, although some of the justices who have embraced the independent state legislature theory have suggested that it might be a holding, but it's not a holding. It's its own constitutional avoidance. The Supreme Court said, we're setting this back and we want the Florida Supreme Court to tell us what it was doing. The Florida Supreme Court then made it very clear in both that case and in the case that became Bush versus Gore that it was just doing statutory interpretation without reference to the Florida Constitution. When it comes back, when the election controversy comes back to the Supreme Court in the form of Bush versus Gore, as almost everybody knows, right, the Supreme Court stopped the recount in Florida by relying on the Equal Protection Clause in a 5-4 opinion. But 3 justices, the Chief Justice, who at the time was Rehnquist, joined by Scalia and Thomas, had a concurrence that argued that that Article 2, giving the legislature the power to decide how the electors would be appointed constrained the Florida court in its interpretation of the statute. And it said, without any citation or support that I am aware of at all, or there is no citation or support, I don't think any exists, said that this actually limits the nature of the type of statutory interpretation that the court could engage in, that it had to be a kind of textualist interpretation. Although that's not entirely what the court did, but the opinion did also include some purposivism. But that's where it was sort of laid out in its foundation.
So Wilfred, to piggyback on that, this question about what the word legislature means in Articles 2 and 1 and elsewhere in the Constitution certainly obtained a lot more salience in Bush versus Gore, where 3 justices, as Carolyn points out in the concurrence, featured it. 4 other justices repudiated it, by the way, which kind of underscores how the remand in Bush 1 couldn't have resolved this question. Otherwise, you wouldn't have had more justices rejecting than accepting the independent state legislature notion in Bush versus Gore 2. The question actually goes back before that. I wrote an article in the William and Mary Law Review in 1999 that was published in early 2000, well before the election, talking about what the word legislature means in various points in the Constitution. In fact, I think I might be the first one to use the phrase independent legislature to capture this notion. But what happened after Bush versus Gore is the equal protection rationale that got just savaged by academics fell into disfavor, and that no one on the Supreme Court wanted to touch that with a 10-foot pole because it makes no sense. And so I think, kind of sophisticated conservatives who grew up during that time at the end of the last century, they came to think, well, Bush versus Gore might have been right, but for the reasons embraced by the Rehnquist concurrence, not by the majority. So they latched on to this notion that the word legislature would mean nothing unless it means what they say it meant, which is a completely independent legislature untethered from the state constitution and state judicial review. That's not remotely true. The word legislature still has meaning, even if it doesn't connote what they say, for reasons that I think all of us could explain and have written about. But I think the reason why this goes back to Bush versus Gore is because there were 3 justices who full-throatedly laid out this theory, and not that many people engaged it in the interim. It kind of lay fallow. And so it made a resurrection leading into the 2020 presidential election. And that's when a lot of us, including myself, started thinking, hey, we thought this thing was put to bed once and for all. We better yell loudly to explain why this is complete rubbish, as I say in the title of my most recent article.
And I want to get to the 2020 election in a moment, but I'd like to ask a question to Kate and Leah. I mentioned originalism earlier on. It has this cousin, we'll call it, an interpretive theory called textualism. And you write that textualists claim that theirs is the only interpretive method that respects the limited role of unelected judges in a federal system. Can you tell us what textualism is and what it actually has to do with the independent state legislative theory? And also, can you square the circle that in this context, textualists are calling for increased and enhanced federal judicial intervention?
Maybe I'll start and then pass the mic to Leah, if that's okay. And one thing I wanted to say is, so we've been talking in general terms about the use of the term legislature. Maybe I'll just quickly recite the constitutional text that is at the heart of this theory, because I think for listeners, viewers who aren't familiar with it, it might be useful. So Article 1's elections clause provides that the times, places, and manner of holding elections for senators and representatives shall be prescribed in each state by the legislature thereof. Okay, so the key term there is legislature. And the claim that I think both Vic and Carolyn's article really effectively debunks, sort of soup to nuts, is that the claim of proponents of the theory is that this term legislature exists independent of state constitutional provisions creating the legislature, maybe providing for judicial review of the enactments of the legislature, that somehow the legislature stands apart from other organs of and norms and rules of state governance in, I think, this very sort of overly federalist vision of what a legislature even means or looks like. So that's Article 1. And then Article 2's Presidential Electors Clause provides that each state shall appoint in such manner as the legislature thereof may direct, again, the word legislature, a number of electors equal to the whole number of representatives to which each state may be entitled in Congress. So both have to do with federal elections, the first congressional elections, the second presidential elections. And the claim is that the legislature's power here is plenary and exclusive and independent of any authority on the part of other state entities, arises, it's related but distinct. So we have the context of federal congressional elections and federal presidential elections. Okay, so I just wanted to put the text of the Constitution out there. In terms of your question about sort of the role of textualism, I mean, I think there are a couple of ways in which the claim, this independent state legislature, either theory or, as Carolyn's piece calls it, claim, I think either referring to it as a theory or a claim is far superior to referring to it as a doctrine, right? It's not been accepted. And in fact, it doesn't really have the coherence of a doctrine, I think. So claim or theory is the best way to describe it, to my mind. But it has, textualism, I think, is at the heart of it. So I think the way that Leah and I focus on one aspect in this piece that we have drafted. So we focus on one circumstance in which this claim arises, which is where a state court or a state executive branch entity has interpreted a state statute related to, election administration, typically, and sometimes in explicit light of state constitutional voting related provisions, reads a state statute in a particular way. And the claim is that federal judges can override the interpretation by state officials, by themselves, federal judges, reading the state statute in a way they think is proper, reviewing it de novo, and reviewing it in using textualism as the only legitimate and defensible method of statutory interpretation with which to interpret that state statute, and sometimes correcting supposedly insufficiently textualist interpretations offered by state courts or state executive branch actors. And so interposing their really textualist grounded interpretation of the statute on other state interpretations. And so briefly, sorry, let me back up a little bit before you asked broadly, what is textualism? So a method of interpretation that, is longstanding, has had, earlier iterations, arose in its sort of current or, relatively current incarnation, I would say in the 1980s when Justice Scalia was ascended to the Supreme Court, and to a degree when he was on the DC Circuit, that disavows reliance on extra textual sources like statutory or legislative history or purpose or context, and focuses, at least officially, on the text of the statute, and then allows consultation of extrinsic sources like dictionaries and canons of interpretation, either textual or substantive canons. But so that's essentially textualism as a method. And as Leah and I explained in this article, and then I'll stop and pass the mic to Leah, textualism developed as a method, in the context of federal courts interpreting federal statutes, and with very explicit reference to the norms of legislative passage that obtain in the federal system, and in fact have very little to do with the process of the passage of laws in the states at all. So it's a profound category error to suggest that textualism, even if it is the right way to interpret federal statutes, is appropriate or mandated when it comes to the interpretation of state statutes. And that, in fact, is at the heart of the independent state legislature claim, at least in the context in which Leah and I are talking about it, which, is somewhat distinct from the context in which state legislatures assert the authority to themselves directly appoint presidential electors, irrespective of whatever vote has been cast in the state. So maybe I'll stop there and let Leah pick up.
Yeah, so I'll just pick up kind of where Kate left off, bringing it back to kind of the iteration and origin in Bush versus Gore of this idea that the elections clauses and electors clauses allow federal courts to basically review state courts' interpretation of state statutes. The kind of conceit or the premise of the claim in Bush versus Gore was that the state courts had gotten state law so wrong, they had interpreted state law so incorrectly that created a federal constitutional problem. And just going back to your first question, Wilfred, like when we're asking, like, where is the original evidence to support this independent state legislature theory or claim, I think it's helpful to underscore how odd it would be to allow the federal courts to review state courts' interpretation of state law. Like, that's wildly inconsistent with just basic foundational premises of how federalism is supposed to work. And so if the elections clause, if the electors Clause did that, we would expect there to be like considerable evidence pointing toward that if those clauses inverted this core principle of federalism. You know, it's just kind of like a baseline premise about how our system of government works, that state courts are the final say about the meaning of state law. That's why the litigation, you know, around SB 8 came to a standstill, because it's the Texas Supreme Court that gets to be the one that says what Texas state law actually means. And what the Independent State Legislature Theory does is say, well, that's true, except when it comes to the state law regarding federal elections. In that circumstance and that circumstance alone, federal courts get to be the ones to decide whether state courts have properly interpreted state law, such that, you know, it's still the legislature that's making the state law governing federal elections. And given, again, how at odds that arrangement would be, that allocation of decision-making authority would be, we might expect there to be like a lot of evidence from history, a lot of historical practice, a lot of constitutional text making perfectly clear that yes, that's going to be how things operate. But of course, there's no such thing, which makes the theory and the claim, you know, all the more odd and, you know, unsupportable. And instead, you know, as that kind of articulation and explanation of the theory makes clear, you know, it is an assertion by the federal courts of power to aggregate to themselves the ability to interpret state law regarding federal elections. And just one more thing, kind of picking up on where Kate left off, you know, in our piece, you know, we talk about how the premises of textualism don't map neatly onto the states, given that states structure their governments in different ways than the federal government does. You know, there isn't a perfect or like as, you know, clear of a system of separated powers. There isn't necessarily a pure system of bicameralism and presentment in how they pass state laws. State judges are elected. Many state judges are elected, unlike their federal counterparts. And so the premises of textualism just don't apply. And so what the Independent State Legislature Theory kind of does is it forces on the states and on the state governments basically an arrangement about how they must structure their governmental systems and how they must allocate decision-making authority and interpretive authority within the states in ways that, again, just run totally counter to the idea that, you know, part of what makes the states governments in our constitutional system is their ability to structure themselves as governments and decide how to allocate decision-making authority within their own governance systems.
Well, can I piggyback? Because I think Leah made a lot of amazingly good points. So, you know, the title of this session is The Threat That ISL Poses to Democracy. And I didn't know that was the title until today. I actually think an equally good and somewhat better title would have been The Threat It Poses to Federalism. Because the cases that we've been looking at involve state courts vindicating state constitutional rights to vote in a way that accords with my sense of what democracy is. But I could imagine state courts interpreting state laws so not so expansively, and yet still it would ultimately be a matter of what those courts thought state law meant, and federal courts have to respect that. The one tiny tweak I might make to what Leah says, in the piece that my brother Akil Amar and I have on this coming out in the Supreme Court Review any week now, we concede, at least arguendo, that Articles 1 and 2 make the question of what the state's election law is in a particular area a federal question for purposes of federal court review. But that doesn't mean that the federal courts decide it anew. When the federal government, for example, incorporates state law by reference in federal territories and say we want the federal law to be whatever the law of the state is in that general jurisdiction, then the federal courts essentially look to the highest state court to decide what that is, unless there's some clear countervailing federal norm. And there is no such countervailing federal norm here. The only federal norm in the mix is that states get to make this decision along the lines that the latitude that Leah rightly described, that is federalism.
That's great to clarify there. And there's so much there that I want to follow up on. But I do want to come back to like the bigger point, which is that the U.S. is unique for splitting the atom in elections. We were talking about this federalism here. The Constitution gives authority to the states to legislate on federal elections, though Congress does have preemptive power, and it defers to the states almost entirely on questions regarding the regulation of state elections. Again, there are some constitutional limitations. This design is totally implicated, as we're talking about. What are, and Carolyn, maybe you would be best positioned to answer this, given your paper. What are the potential consequences for election administration if the independent state legislative theory were embraced by a majority of the court?
There are a number of extremely disruptive consequences, and the fact that they would be so disruptive in and of itself, I think, is evidence that this is completely sui generis, that comes out of nowhere and has no basis in history or practice. But let me give you some examples. Most states have one set of election laws that apply uniformly to federal and state elections. They have what sometimes they call it a unitary election system. There are different names for it. But when we go to the polls, we generally are voting for a combination of state and federal offices. If the ISL claim were adopted in its sort of most full-throated form that several of the justices seem to have embraced, we could have a situation where the same exact statute would be interpreted differently with respect to federal elections and with respect to state elections, because the state court's interpretation would stand, at least under current theories of federalism and precedents, would stand with respect to state elections. The federal courts really have nothing to say about that. But the federal courts, and in particular the US Supreme Court, would have the right to say, yeah, we don't agree with the way the state court interpreted this because we have our own special textualism approach. And so we are going to say that for purposes of federal elections, it means something different. So just to give you an example of that could have happened in 2020, it didn't because of the litigation choices made by some of the parties, but the Pennsylvania Supreme Court concluded that the election statute there allowed state boards of elections to set up drop boxes. They said first, the statute itself is ambiguous as to this point, but we will construe it in light of our state constitution and our free and fair elections clause, and say that therefore, if a state board of election wants to, or a county board of election wants to, can set up a drop box. Under the ISL theory, if that could go to the Supreme Court, we could end up with a situation where those drop boxes would be invalid for federal elections if the Supreme Court disagreed with that interpretation of the statute. The same is true when it comes to holdings that particular parts of a state election law are unconstitutional, or all of a state election law are unconstitutional. If a state constitution can't limit what the legislature does, then a state Supreme Court holding finding that some kind of election law is unconstitutional can't apply to federal elections. And that could lead not only to two disparate systems in the same election cycle, it could actually lead to unending litigation. In 2021, the New Hampshire Supreme Court said that a particular election law having to do with registration was unconstitutional under the New Hampshire Constitution. There was no cert petition filed. You'd think that would be the end, but the theory of the ISL claim might allow somebody to go to federal court anytime and say, no, actually, for purposes of federal elections, we want to revive that state law that the New Hampshire Supreme Court struck down.
And that's really, I think the point you raise about election administration, we're administering two elections at any point, right? We have the state and we have the federal. And in fact, if we look back at history, that's why we have the 26th Amendment, right? Because there was a push in some of the states to lower the voting age to 18. Congress wanted to do it, and the Supreme Court said you can't do that. And so we had to actually amend the Constitution, which we know is really difficult, to make sure that we didn't have this dual system in the states. I do want to go back to a point that Kate and Leah raised. You talked about whether federal courts should actually be intervening at all. Is there a principled distinction for when federal court should be intervening in state courts, like when things have gone so awry? In the Bush v. Gore decision, Justice Ginsburg made a particular appointed argument that, we would be bracketing the decision of the Florida Supreme Court with some of the state Supreme Courts of the Jim Crow South era, if by going about it in the way that the three concurring justices wanted to do that. Do you have a sense of what is a permissible or in principled way of deciding when federal courts should have to intervene?
So I think that the examples that Justice Ginsburg gave that you alluded to, provide the right baseline, because they underscore the extent to which, it is the, again, default rule that state courts' interpretations of state law are, deferred to, kind of the final say on the matter, so on and so forth. And the instances where the Supreme Court has said, no, that's actually not the case, were instances like NAACP versus Alabama, where the state courts had basically so manipulated state procedural rules so as to, prevent the NAACP from challenging the state court's order to disclose, lists of their members and expose them to untold violence. Like when the Supreme Court said, actually, no, state courts, you messed up state law on that issue, they were able to point to, clear examples of other state court decisions that the state court, was inconsistent with. It wasn't just like, oh, well, like you came to one interpretation of the statute, but I actually think there's a better one. It was, a clear evidence of abdication, a clear evidence about why they did so in order to expose members of the NAACP to racist violence. And, again, given the context in which those decisions were made, the civil rights era, I think that kind of underscores the, baseline against which we expect the federal courts to generally defer to state courts' interpretation of state law, and the circumstances in which they shouldn't, right, are circumstances akin to, Jim Crow era South, in which Southern state courts were functioning like kangaroo courts, basically just legitimizing violence against, civil rights protesters and, Black Americans. So I think that the example that Justice Ginsburg made, as a former civil procedure professor, is a good one. And again, underscoring the extent to which independent state legislature theory and this claim of authority on the part of federal judges would, again, be so inconsistent with just how the normal course of our federal system works.
Right. And if I could just add one thought, which is, wherever the line is in terms of permissible federal judicial intervention here, it has to be, the valence of that intervention has to be in the direction of safeguarding the right to vote. And the interventions, or the, not yet majority commanding, but efforts to urge federal court intervention on the basis of this theory have, in the 2020 cycle, all had the opposite valence, right? So they have been in the direction of curtailing state efforts, right? Efforts by state bodies to facilitate access to voting in federal elections. And wherever the line is, it seems to me that it, again, has to be in the direction of either a complete sort of abdication or breakdown in state processes, as Leah was just describing, or in any event, in the direction of facilitating rather than thwarting access to voting. And particularly in the name of safeguarding sort of state processes, which is like, again, how the theory is framed to safeguard the federal constitutional sort of empowerment of the state legislature. But all of that, is actually done, I think, in kind of profound disrespect of state institutional design and allocation of authority choices.
Can I just add? I mean, Kate and Leah were exactly right. The question is whether there's a federal interest here. Now, maybe there's a federal interest in some minimal form of state judicial regularity and not a result of manipulation. And there may be a federal interest, as Kate pointed out, in the direction of the right to vote. There are also a lot of federal statutes that play here. The time for selecting electors has to be on the same day. There are obviously, Wilfred, you mentioned the 26th Amendment. There's the 26th, there's the 24th, there's the 19th, there's the 15th, et cetera. The key question is, where is the federal interest here? And the ISL proponents say there's a generic federal interest in empowering the legislature of each state vis-a-vis any other institution within the state by virtue of the bare use of that word. And as Leah pointed out, if that were true, you'd have expected a lot of history and discussion in that direction, and far from it. It's all the evidence suggests the other direction.
So you guys are raising such great questions, and I have so many points to come back to. But one of them is what Kate and Leah were both just speaking about, and that is basically the 2020 election, right? All of your scholarship has touched on the 2020 election cycle. Actually, it's a common theme for all of our scholarship. I've written about the pandemic primary and the presidential election with respect to the Purcell principle in the shadow docket. But perhaps it would be helpful if you can talk about that pivotal election cycle. What can we learn with respect to the independent state legislative theory coming out of the shadow docket decisions and the dissenting opinions there? And maybe you can provide some update of what this might mean in 2022 as we're undergoing this redistricting cycle and midterm elections.
Caroline, I think you're muted.
You'd think after 2 years, I would remember to unmute. I think some of the cases in 2020 demonstrate just how malleable this textualist approach to ISL is, and how it allows for incredible gamesmanship on the part of litigants. In the North Carolina litigation, for example, there was a settlement reached between the Board of Elections and some plaintiffs that led to the extension of the absentee ballot deadline. And the state courts, including the state Supreme Court, said that that was within the Board of Elections' power, that it was, and that the legislators, there were 2 legislators who had intervened, which they had the right to do by statute, but the court said that they didn't have the power, the state court said that they did not have the power to stop the settlement. They didn't have to agree to the settlement in order for it to go into effect. In the Supreme Court, Justice Gorsuch wrote an opinion in which he essentially said that he accused the plaintiffs and the state trial court of collusion. He said they rewrote the laws. And he said, of course, that's in part, he said, it's because there's no natural disaster, which is the law that gives the Board of Election a certain amount of flexibility in North Carolina. Of course, this isn't a natural disaster. This is a pandemic. Now, if you go back and you look at North Carolina law and the way that North Carolina law has used the word natural disaster with respect to the pandemic, that's not at all obvious. So it basically allowed Justice Gorsuch at the last moment, without full briefing, without argument, to reject on the basis of his own interpretation of 2 words in the statute, something that all of these different bodies in the state had come to a different agreement about. So that's one problem. Another is that he has suggested in that opinion and in others that state legislatures may be limited, not only that state legislatures themselves may be limited. It's not just a question of whether state courts can do their jobs, whether state election administrators can do their jobs, but also that state legislatures themselves may be unable to delegate something to election administrators. It's something sort of a version of what we are seeing now in the revival of this major questions doctrine. If a justice thinks it's too big of a question or too big of a delegation, the ISL would allow the justices to say, yeah, no, we don't think that was permissible. It has to be the legislature to make those decisions, which could be incredibly disruptive of longstanding professional election administration. So those are just a couple of ways that the 2020 election illustrated the dangers and the amount of discretion that the ISL theory arrogates to the Supreme Court. The way that they are, the justices who have embraced it, talk about it, it gives them this incredible amount of discretion and authority to come in and say, no, we don't agree, which then creates incentives for the parties to selectively appeal different types of issues to the court. You can end up with a really bizarre patchwork where certain decisions are left for the state courts to decide, but the Supreme Court jumps in others because the parties think that's strategically helpful to go to the Supreme Court with particular questions.
And something Caroline just raised was, and Vic as well, I guess, 2 points. One is about procedural and substantive distinctions here, and general and specific enforcement here of constitutional provisions. So what would be great is to have some clarity on the distinction between the procedural and substantive federal election lawmaking requirements in the context of this theory, and what the court has said about either, and whether it has been consistent. And I guess the same would be helpful in terms of the enforcement of general versus specific provisions of the Constitution. What does that like here?
So I'll answer what I think is the gist of your question, Wilfred. There are 4 huge Supreme Court cases in which ISL notions had been raised in the past century or so. In Davis versus Hildebrandt, the question was whether the people of Ohio could oversee the congressional districting process that had been engaged by the Ohio legislature. The legislature said, no, under Article 1, this belongs to us, not to the people of Ohio. Supreme Court rejected that. In 1932, in Smiley versus Holm, the claim was that the governor cannot be involved in congressional districting because the governor is not part of the legislature within the meaning of Article 1. Again, the court rejected that. In 2015, in what I think is one of her best opinions that's underappreciated, Ruth Bader Ginsburg wrote for a 5-4 majority, rejecting the notion that the voters of Arizona violated Article 1 when they took power from the elected state legislature to draw congressional district lines away from that legislature and convert it in a so-called Independent State Redistricting Commission. Again, the full-throated claim was that under Article 1, this belongs to the elected legislature, and the state constitution cannot give that job to somebody else, and the court rejected that. And then 3 years later in Rucho versus Common Cause, the dissenters in the Arizona case, Chief Justice Roberts, wrote an opinion which expressly validated the device at issue in Arizona and expressly validated rulings by the Florida Supreme Court that had invalidated Florida statutes regulating congressional elections on the ground that those statutes violated the Florida Constitution. So ISL has been repudiated time and again, which makes it kind of hard to understand why 3 justices, Thomas, Alito, and Gorsuch, have in recent months indicated that they agree with the theory, at least provisionally. It's not quite 4 because Brett Kavanaugh has pointedly not joined those other 3, even though he started the ball rolling here in 2020 when he wrote separately in a case out of Wisconsin. But he's backed away from those other 3. Interestingly and importantly, Wilfred, to go to your question about what's going to happen going forward, Chief Justice Roberts seems to understand clearly the point that Leah and Kate make about the difference between federal and state courts intervening in a federal election. So I'm hopeful that Chief Justice Roberts is fully on board, and I'm also actually quite hopeful that at least one of Justice Kavanaugh or Justice Barrett will see the light here. But this issue is not going away. They're going to grant sooner or later, as Wendy pointed out in the intro.
I'd love to follow up on that point. So recently we have seen 4 justices embrace it. You mentioned Alito, Gorsuch, Thomas, and Kavanaugh. Thomas was on that original 3 in the Bush decision, or the concurrence. We have seen, despite it seems like he's stepping back, the Chief Justice endorsed it in some regard, right, in the Arizona decision that you mentioned. And it was his former boss, Chief Justice Rehnquist, that was the writer of the concurring opinion, Bush v. Gore. We don't know anything about Justice Barrett. Do any of you have any thoughts about what we should expect in terms of these combinations? And is it something we should expect in certain instances where this theory might apply, and it might be applied not in other instances? Beyond just hope, I guess, where can we see this going forward? Like, is there a path forward on the Supreme Court?
I mean, it's a little bit difficult to know. As Vic noted, it's certainly possible that at least the Chief Justice believes there is a distinction between cases coming out of like federal courts versus state courts when they're challenging, election restrictions. But part of what makes this so difficult is a lot of these cases were decided on the shadow docket, which means there weren't, arguments in the cases, there weren't full opinions. And so we don't have like clear statements from the justices who, for example, voted not to hear the Pennsylvania cases, or who even would have stayed one of the Pennsylvania cases in the lead up to the election. Like, we don't know why they did so. We don't know why the Chief Justice didn't do so. And so it's a little bit difficult to know exactly what the fault lines will be. I certainly agree with Vic that one possible fault line, one likely fault line, is whether a case arises, in federal court or state court challenging an election restriction on federal constitutional grounds or state constitutional grounds. I think that that's one fault line. And then, as to your other question, just about like the predictions with Justice Barrett, I mean, in some ways, we talked about the origin story of this theory in Bush versus Gore. Like, in some ways, the most probative thing is like she was on the Bush campaign, that argued for, this theory when they asked the Supreme Court to stay the recount and, declare President Bush the winner. So, that's certainly some indication. I mean, the only reason this theory has legs is there are at least 3, justices who are on the Bush campaign who are now on the Supreme Court in a position to make that theory into the law. And so I think that's a sign that she's probably not going to reject it wholesale. And the only question is like, what are the limits on this theory? That she or Justice Kavanaugh or the Chief Justice might be possibly open to.
Great. And Leah, actually, I'd love to ask you a specific question. In 2016, I think it was, in the aftermath of the Shelby decision, you wrote an article called Inventing Equal Sovereignty that appeared in the Michigan Law Review. And it talked about how the court raised up this obscure principle, one that was related to the admission of states to the union and not related to Section 5 of the Voting Rights Act, and used that to render the crown achievement of the civil rights era inoperative. We now know that when the court mentioned that notion of equal sovereignty, the passing decade before in Northwest Austin, those were kind of breadcrumbs or flares of what it was going to do. Is this what we should be expecting now? Is this now the MO of the court to just simply raise up some principles or fringe theories and dicta or concurrences or even in fortune cookies, I don't know, to just say, if we say this enough, it's going to become law?
I think that this is an MO of the Roberts Court. You mentioned Shelby County and the Voting Rights Act as one example of that. I think another great example is what they did to public sector unions, basically chipping away at, Booth, the case saying that public sector unions could charge fair share agreements. I think, we are on the precipice of seeing them do the same with Roe, chipping away, and then outright overruling. And I think independent state legislature theory is, we are possibly heading down that path as well. The one kind of saving or one like hope I have out of this is it seems like more people are paying attention to the possible emergence of this theory than we're paying attention to, the other doctrines that the court was kind of hinting at and toying with before they ultimately like use those doctrines to, completely eviscerate, either federal statutes or, important state law arrangements. And then the other kind of like bright hope is, again, like we don't have a majority opinion yet, or a majority opinion embracing like the most expansive version of ISLT. And so I think now is really the time, for more people to invest in learning more about this theory, understanding its flaws, and, seeing what they can do, both on like a legal scholarship litigation side, but also on, more like political engagement side, what they can do to kind of prevent this theory from gaining ground and getting traction.
Right.
And could I add 2 points to that too? Because I think Leah and I may disagree on some of those cases. I agree. Shelby County was a great essay, and that's a good. I would throw in Sebelius and the Obamacare case. This idea that there's a distinction in the Commerce Clause between activity and inactivity came out of nowhere. I would have called that a fringe theory in 2008, but it's a setting in which the politics overtook the analytics, and by the time it got to the Supreme Court, it had 5 votes. One thing I think is kind of interesting, we all probably read Justice Alito's draft opinion in Dobbs, and the way it went out of its way to show how little support there was for the way Roe was written. If the justices who sign on to such an opinion in Dobbs have any sense of kind of intellectual consistency, they're going to have to grapple with the fact that whatever you think about ISL as a policy matter, it's completely made up as an originalist and textualist and precedentialist matter. So just after they say those things about Roe, if they want to make up yet another thing out of the blue, it's going to be particularly, I think, galling to a lot of us. The final thing I want to just add is, it's not coincidental that the ISL is being pushed by Republican advocates and not Democratic advocates, because we've seen that state courts sometimes repudiate, in the name of the state constitution, the work product of Democratic legislatures in congressional districting. We saw New York do that. We saw Maryland do that, et cetera. But here's a very interesting and not coincidental factoid. There are 7 states that Biden carried that have Republican legislatures. There's not a single state that Trump carried with a Democratic legislature. So the ISL notion is not completely devoid of partisan consequences, and nobody who's opening their eyes and looking can ignore that.
Great. And I want to ask a question for all of you, actually, and maybe Vicky, you'll have a little bit more insight on this too, given that you covered a bit of Bush v. Gore more broadly in your paper. But that Bush v. Gore saga ignored the gross disparities in voting in Florida and raised them up in the U.S. more broadly. We've seen Shelby County versus Holder, where the court eviscerated Section 5 functionally of the Voting Rights Act, which required pre-clearance from the states with historical discrimination in voting. Last year's Bronovich decision, it dulled Section 2 of the Voting Rights Act in the vote denial context. So that's legal obstacles to the casting and counting of ballots. And in this year, in the shadow docket, we see the court has signaled its willingness to render that same Section 2 pretty much useless in the vote dilution context. So you can crack and pack Black folks and other folks in the redistricting context to water down their vote. And we also saw in the pandemic that what they did in the context of Florida law that would have re-enfranchised formerly convicted persons, where a Florida trial court said that would constitute a poll tax in effect. To put it mildly, this court has not been an ally of particular members and communities in the American electorate. Does the ISLT fit into this paradigm? What does it say for voters of color throughout the country and poorer voters, and just really the most vulnerable segments of the American electorate trying to register their desires, values, and political will?
Well, I think it's very much related. And there are all kinds of ways we can talk about that. But one has to do with gerrymandering and Rucho, right? In Rucho, the court said, well, federal courts can't say anything about partisan gerrymandering. And so what we have now are many, many highly gerrymandered state legislatures, in several of them in highly contested states like Wisconsin or North Carolina. And so if we have legislatures that are not representative of the people of those states, which is the case because of Rucho in part, then the ISLT reinforces that at the federal in federal elections and in particular in presidential elections, that it would allow that unrepresentative legislature to override the will of the voters in a variety of different ways.
I can just piggyback on that for 1 second, and just to highlight a great law review article by Miriam Seifter at Wisconsin called Counter-Majoritarian Legislatures, because at the heart of the ISLT is this romanticized notion that a legislature is the most representative body in a state. And so it vindicates principles of representation and democracy to empower the state legislature. But in reality, state Supreme Court justices are often elected by the entire state, as opposed to this kind of gerrymandered representation in the state legislature. In a state like Florida, sometimes you can manage to put on a ballot statewide a reenfranchisement measure that improbably, because of really intense and amazing organizing, passes. That is far more reflective of the democratic will than anything the legislature enacts. And so the ISLT, I think, quite by design, in the context of actual dynamics of representation and democracy in the states, is profoundly anti-democratic.
There's an
Exactly.
example of that.
The reason why, there are 7 Biden states with red legislatures is not just because Republicans gerrymander. Both sides gerrymander when they can. It's that in a lot of places, Democrats are already packed because they live closer to each other. So it's easier to leverage a minority position or a bare majority position into a more stable majority position in the legislature. And it's ironic, as cases like Rucho that Carolyn mentioned, and all the cases, Wilfred, that you and that Leah talked about, that narrow the scope of application of federal rights, whether they're federal constitutional rights to vote or federal statutory voting rights to vote. Everything got pushed in the direction, okay, well, state courts and state law, that's the bubble in the rug. That's the kind of the place where it all resides. And ISL seeks to stamp that out as well.
Well, we're at the point right now for audience questions. And so I have a couple here. First, what does the Independent State Legislature Theory mean for federal laws governing federal elections? Under that theory, for example, can legislators legalize unlimited corporate contributions or unlimited or corporate contributions to federal candidates?
So, independent state legislature theory, or like some iteration of it, has been invoked by some justices as kind of like a canon of constitutional avoidance and how to interpret federal statutes. In a case challenging Arizona's proof of citizenship requirement for voting, a majority of the court, in an opinion by Justice Scalia, held that Arizona's proof of citizenship requirement was preempted by the National Voter Registration Act, which allowed individuals to register to vote using this uniform requirement. In a separate writing, Justices Thomas and Alito indicated that they would have read the federal statute more narrowly to permit Arizona's proof of citizenship requirement, because reading it broadly in the way that the majority did raised what they viewed as constitutional concerns in light of the Constitution's allocation of authority to state legislatures to make the rules governing federal elections. So kind of like beyond that, that is like a possible canon of constitutional avoidance. And then, even more strongly, a possible basis on which to strike down federal statutes as exceeding federal authority over elections. Those are kind of the ways that we've seen ISL theory, or some, variations on it kind of being floated when it comes to federal statutes regarding federal elections.
I might add one quick thing, and that is, Wilfred, you mentioned earlier that Congress has a role to play in regulating federal elections. That's certainly clear with respect to Article 1 in congressional elections, because the backup principle says even though states get to prescribe time, place, and manner, Congress can do so by. There's no provision in the federal Constitution that allows Congress directly to regulate the process by which states choose electors. Now, we have some cases going back many decades, like Burroughs and others, that recognize a federal interest and a federal power there. But the same people who embrace ISL may not be so keen in recognizing broad congressional laws that apply to presidential as opposed to congressional elections, which, for the reasons Carolyn described earlier, make no sense, because state elections, congressional elections, and presidential elections are unitary. And so having different rules in all of them is a recipe for chaos.
Great. I'm going to go to the next audience question. And actually, it might be useful for Carolyn to start with this one, because I have a similar question. I'll add on to it a little bit. What, if anything, can states do to protect themselves in the event of the Supreme Court adopts the ISL? And I'll add to that, because Carolyn, like many great papers, you end yours by adding some courses of action, potential conduct that actors can take. I just also want to ask, while you're thinking about it, if by taking these actions, or by taking these actions, does it legitimize the theory at all? Does it sort of, in a sense, recognize what we are all at this point have acknowledged is pretty much a bunk theory?
So I'll answer your second question first, which is that there are actually different versions of the theory. There are more extreme and less extreme versions. And I think the least extreme version would say that if a state legislature asserts the authority under this theory, that authority should be deferred to. Now, I don't think any of us think that's correct, but that's a relatively narrow understanding of the ISLC. But what the Supreme Court, or the justices on the Supreme Court who've embraced it, have done is something much more expansive than that. So they've said things like, as we've already talked about, we're going to impose our own special textualism as a theory of interpretation, and we're going to decide whether or not the state courts properly interpreted their own law. We're going to say that a state constitutional provision can't apply even where the state legislature has enacted one single law to govern both state and federal elections. So that's it's possible that some of the things I would recommend would at least acknowledge that there might be a way for state legislatures to do this extreme thing, to assert this authority, but it doesn't necessarily require that conclusion, and it certainly doesn't lead to this much more expansive approach. So, for example, state legislatures could say when they enact laws, these laws are subject to the state constitution. Or they could have a standalone law that says all of our election laws incorporate by reference the state constitution and all of the ordinary state statutory interpretation processes and laws, some of which are statutes themselves. And that would actually give, if to the extent that the ISLT is supposed to be this pro-democratic, pro-political accountability idea, that would mean that if the legislature wanted to assert this notional authority, it would then have to say that's what it was doing. The way it operates right now, or at least the way these justices suggest it might operate, it's all sub silentio, right? Later on, the Supreme Court gets to come in and say, oh, no, we don't think that's what the legislature did here. But the legislature never says that, and the people have no opportunity to register their views on that. So that's something a state legislature could do. A state Supreme Court can write in a very clear way about how what it's doing fits into state law. Sometimes when state courts write their opinions, they're writing for the audience of the people in the state, right? The lawyers in the state, the legislators in the state, the parties in the case. But I think they should be writing in these election cases with an eye also to the federal courts, and in particular the Supreme Court, and explain why it should be understood that the legislature was legislating against this background of state law, and should be understood that they incorporated that state law into whatever election law they are construing or deciding on the constitutionality of. So none of these things would eliminate the possibility of the Supreme Court doing what these justices have sort of been hinting at, but it would at least make it harder. And frankly, it would make it more obvious that what they are doing is not consistent with what the states themselves think they are doing, state legislatures and state courts alike.
So I have another audience question, and we are going to be moving towards the end soon. So I'll ask this one, and then I'll think of a bigger question for all of you to weigh in on. The audience question is, how does this theory relate to efforts we've seen to overturn the results of the 2020 election?
I'm happy to maybe say a couple things about it, and then Leah, I'll turn over to you. Well, look, I mean, we actually got some disclosures, I think yesterday or earlier today, some additional communications between former Trump advisor John Eastman and some Republican legislators rather in Pennsylvania that I think actually are a perfect illustration of the answer to that question. And you basically have Eastman urging Republican legislators in Pennsylvania to do some attempt to retabulate the state's popular vote, to throw out, tens of thousands of absentee ballots, and then to directly appoint Trump electors. Because again, Carolyn sort of mentioned there are, I think, gradations in terms of the kind of strength of this claim, this independent state legislature claim. And, the kind of most dramatic and, unprecedented in the modern era, I mean, ever, in terms of actually throwing out votes. But the most extreme version is the sort of Article 2 version having to do with presidential elections and presidential electors. And it basically claims that because the legislature has the power to choose the method by which electors are appointed, the legislature could retain for itself the power to directly appoint electors, including, it seems, at least according to this Eastman exchange, after individuals have cast votes pursuant to state law that assigns to the people, as every state's law does, the power to select presidential electors. Now, as a matter of history, since 1860, every state has given the people the power to choose presidential electors rather than retaining it again for the legislature itself. And it was only 1860 because South Carolina held out for about 3 decades after the point at which every other state, and I think 1832, had given its population the power to appoint, or the subset of its population, of course, at the time, but the power to appoint its electors again, or just elect its electors rather than, again, appointing as the legislature outright. But despite this extremely long history of popular selection of electors, it seems that what this theory suggests is that legislatures could seize back, claw back the power to appoint electors, including after people have voted, and including to appoint electors inconsistent with the expressed will of the people. So, of course, none of that was successful in 2020, but it is the ISLT that underlies this effort. And one other sort of interesting thing, I think, to flag in that exchange, sort of, again, these newly released documents, in this exchange, again, between Eastman and a Pennsylvania GOP lawmaker, Eastman is suggesting that it's important to do this kind of retabulation to provide some cover for the efforts to do the appointment outright. Because even though the theory claims that legislatures have this power, they can do it under Article 2. They don't have to listen to what the people have said with respect to their presidential electors. They can just appoint electors themselves. There's at least an acknowledgement that the kind of constitutional culture and history would be a substantial obstacle to an acceptance of a legislature's efforts to actually do this thing. And that, I think, sort of, Leah said something earlier about the importance of, scholars and litigators, but also sort of those who kind of speak more broadly to the public about these constitutional values, sort of making clear how perverse and anomalous an effort, again, to seize back this power to appoint electors, in particular after people have already voted, would be, from the perspective of kind of basic constitutional principles and our history. So I think there's the question is important, and the efforts around 2020 have everything to do with this doctrine.
And so we're nearing the end. So I want to ask a sort of bigger question, and hopefully all of you can weigh in to some extent. Were it not for the Electoral College, 5 of the current Republican-appointed justices would not be on the court. 2 of them were appointed by George W. Bush. 3 of them, as we noted, have worked on the litigation and the controversy that raised the ISLT recently. And this theory has implications for the Electoral College, for political and racial gerrymandering, for voter identification laws, and other core areas of election law. And you also raised what's happening in Dobbs and what's the theories put forth in the Affordable Care Act, the union cases. I'm concerned about the legitimacy of the court. Do these justices now see this as a legal way to maintain conservative power in government and on the court, controlled by a political minority? Or please convince me that there is some other explanation for ignoring history and precedent and short-circuiting statutory analysis and all the things that we're saying are going on in support of this theory.
Well, I'll venture a thought here. First of all, I don't want to argue with the hypothetical, but strictly speaking, we don't know who would have won under a direct popular election in 2000 or 2016 because that wasn't the rules in place. So maybe George Bush could have beaten Al Gore if he had known that the point was to win more popular votes nationwide. I don't think so, but it's possible. And of course, Trump claims that he could have had those been the rules in place. But your more general point, I think, is a good one, which is why, as bad as the North Carolina and the Harvard cases may be, or from some people's perspective, Dobbs might be, this is fundamental. This is foundational. Voting rights and federalism are the 2 big underlying theories or structures of our whole constitutional democracy. So to monkey with that without any text or history or common sense or precedent, judicial precedent, is troubling. I just want to go back to one thing Kate said. Changing the electors after the election is particularly problematic because Congress has specified the date on which the electors should be picked. And Congress is given the power under Article 2 to specify that date, which shall be uniform throughout the United States. So going forward, if a state, not the state legislature, but if a state wants to give its legislature the power to pick electors, It can do that under Article 2, but that's very different than the legislature undoing the election that the rules that were in place at the time that Congress said the electors shall be picked. What's particularly troubling, I think, is that there are a couple of proposals that would give the power to state legislatures rather than state judges to arbitrate contested presidential elections. And that runs afoul of provisions in state constitutions. But if the ISL notion prevails, then those state constitutional protections for judicial jurisdiction are irrelevant, and laws like the ones being proposed would effectively give all the power to these gerrymandered elected legislatures. And I think that may be a point of no return.
I think I'll add I agree with Vic's concerns, and I agree with the concerns that are embedded in the question you asked, Wilfred. I think that there are a lot of the scholarship that has emerged since the 2020 election, and speaking beyond the 3 articles that we all have written, is there's been some really deep dives into the history of the electors and the elections clause, into the practice throughout the United States history, that is information that wasn't available when these opinions were written during the 2020 election because they were on the shadow docket. And I would like to think that justices who fancy themselves originalists will pay attention to this really remarkable wealth of scholarship that is going to be before them whenever they confront this issue. And if they reject it, it will look increasingly politicized. They're not to say they're not already politicized, but increasingly so.
The only thing I would add is, in some ways, I think that while it is very important to debunk the originalist basis and like structuralist basis and like textualist basis for independent state legislature theory, in other conversations, I think the most important register to have this conversation in is the one you ended it on, Wilfred, which is, in its current iteration, ISLT is an anti-democratic tool for minority rule. It is a theory that could justify state legislatures throwing out the results of an election and seizing the ability to appoint electors for who they want to be elected. It would be a way of arrogating power to heavily gerrymandered state legislatures and undermining voters' ability to weigh in via state judicial elections and lose the protections of state constitutional provisions, that again, they might have had a role in enacting or otherwise, legislatures enacted against. But that is, to my mind, like the most important thing to understand about the ISLT is just, it is another tool, and in some ways, like the most dramatic, potent tool up alongside partisan gerrymandering for enabling anti-democracy and minoritarian rule.
Yeah, and if I could, maybe I'll just link what Leah and Carolyn just said. I do think that, and it's really valuable for Brendan to have convened this conversation, and I hope that there will be more such convenings and conversations. But I do think that this is a conversation and an effort that can happen, as Leah just alluded to, in multiple registers at the same time. So while sounding the alarm about the profoundly destabilizing, chaos-inducing, anti-democratic potential of wholesale adoption of this theory is really important, so too, I think, is reaching, to the extent that justices like the Chief Justice and Justice Barrett, who I think do appear to have potentially, Justice Kavanaugh, something of an open mind about this, taking seriously the methods to which they have pledged fealty, like originalism, like textualism, Barrett and Kavanaugh more than the Chief on those methods. But all of those point in the same direction, which is this is a theory wholly without substantive and principled justifications. And I think that we can have both of those conversations simultaneously.
Well, thank you so much, Vikram Amar, Leah Littman, Carolyn Shapiro, and Kate Shaw. You have put on a great conversation. You certainly have me a little bit more scared, but your scholarship is really a service to our country. We're so grateful that you made the time for this enlightening conversation today. And thank you to the audience for all of your questions. My name is Wilfred Codrington. You can stay up to date with key issues impacting our democracy with weekly analyses and insight from the Brennan Center experts by signing up for the briefing a newsletter at thebrennancenter.org/briefing. And be sure to RSVP for our upcoming online public events. Thank you all for coming and supporting the Brennan Center for Justice, and have a great day.